Here to explain what's happening at this stage in the trial, our guests are trial lawyer Professor Jennifer Zedalis from the Levin School of Law at the University of Florida in Gainesville. She's practiced law in Florida for 30 years, and she's joining us via Skype, as well as LeRoy Pernell, Dean of Florida A&M College of Law, and he joins us from Tallahassee, Florida. Welcome to both of you. Thank you so much for taking a little bit of time with us. I want to ask you, Jennifer, if I may start with you, are you surprised at all that after 2 days of the jury selection process that no juror has been impaneled yet?
No, I'm not surprised, because this will be a long process. This case has raised a lot of interest in our community and across the nation, and the attorneys in this case on both sides have to work very hard in jury selection. It's going to be a long process, so I'm not surprised.
And what's your assessment of what we've learned so far? I mean, there's been some very interesting banter back and forth, and not really banter, but questioning between the lawyers and the potential jurors. What's your assessment of how it's going?
I think it's going well, and the reason I say that is because the jurors appear to be talking, and any time that you have your potential jurors, I should say, any time that your potential jurors are expressing their views, letting the attorneys and the court know what they've heard about the case, whether that has affected their ability to be an impartial juror. There's been a little bit of humor, as you mentioned earlier. The jurors are talking, and any time that you have jurors who are willing to talk and share their views, and it sounds like these folks are being forthcoming, I think that's good.
LeRoy, let me bring you into this. There were only 10 jurors questioned yesterday and only 4 the day before. This seems like a painfully slow process. Will the pace pick up over time?
Well, I think that the pace will pick up some. This is a tough case in terms of trying to make sure that pre-trial publicity has not unduly affected the need to have an impartial jury. So the court is going to take its time with getting at least the veneer together so that they can begin the process of actually selecting potential jurors. And so I think you'll see, you'll probably see that pace pick up more, maybe double what it is now, but it's still going to take some time.
Let me ask you a little bit about what this jury panel might end up looking like in terms of diversity. Seminole County is not that diverse to begin with, and so to end up with a racially diverse panel might be a challenge. I read in some reading that there is a precedent, Batson versus Kentucky, which,
yes,
which keeps lawyers from excluding jurors based on race, so that you don't have all of one group or all of the other group. But can't the legal team sort of work around that, exclude them for other reasons?
Well, I think that the way in which Batson works, there are 2 levels of potential exclusion of jurors. One is to exclude jurors for cause. Clearly, you cannot use, and even prior to Batson, you could not use race as a reason to exclude a juror for cause. But what Batson does, and the cases that follow Batson, is to focus in on the use of peremptory challenges by the parties in the case, whereas typically peremptory challenges could be used for any reason, so that you could presumably claim no reason at all for wanting to exclude a potential juror. But what Batson forces the court to do is look at the impact of the use of those peremptory challenges. So if it looks, for example, like all the jurors of color, all the African-American jurors are being eliminated for whatever sets of reasons by one side or the other, then Batson kicks in and provides the court with the responsibility to make sure that there is a fair and impartial cross-section of the jury selected.
And speaking of that, Jennifer, is that the judge's role to make sure that the Batson versus Kentucky is in force as the jurors are being selected? And what's her role during this process?
If that issue comes up, and there's always, of course, there's always a possibility that it will come up, the judge has to rule on whether or not there is a race-neutral reason for the exercise of the peremptory challenge, as my colleague was referring to. You cannot use a peremptory challenge to systematically exclude members of a minority or a particular racial group from service on the jury. So if that issue is raised by the opposing party when an attorney attempts to exercise a peremptory challenge against, for instance, an African-American juror, then the judge's role would be to rule on whether or not there is a race-neutral reason which would permit the challenge. And if not, the court will not permit the challenge. And potentially, this could be grounds to strike the panel. So this is an issue that might come up, and the judge has an important role, of course, in that.
And speaking of which, LeRoy, how much pressure is Judge Nelson under to get her rulings right, even now?
Well, first of all, in any case, no judge wants to be reversed on appeal. And certainly in a case like this, with the press coverage, including live coverage of the courtroom, the judge is under considerable pressure to get it right, to make sure that she is not the issue in the case, that in fact the issues will be determined by the facts presented and the decision of the jury. People harken back a few years ago to the O.J. Simpson trial, for example, where one of the criticisms that came out of that trial is that the court let its own process become more the issue than the merits of the case. And I think this judge does not want that to happen.
All right. LeRoy Pernell and Jennifer Zedalis, thank you so much, both of you, for joining us. We appreciate it.
My pleasure.
Have a great day.